4. Testing 1 2 3 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 4. And testing podium.
first matter before the court is Jeremiah Hogan versus Lincoln Medical Partners. This is Lincoln 24209. Counsel appear to be present, and I'm going to ask that you identify yourselves by saying your names for the record, starting with the appellant.
My name is Ron Jenkins, and I represent the appellants in this matter.
Good morning, Your Honor. Joe Mavadonis on behalf of the appellees.
Thank you. I hope we're being streamed live on the web. I know we've had a few technical difficulties here this morning. But with that, if you are ready to proceed, Mr. Jenkins, we'd be happy to hear your argument.
Yes, Your Honor, and may it please the court. The Superior Court erred fundamentally when it held that the PrEP Act immunizes medical professionals and medical practices that administer emergency use authorization products to Maine's minor children in primary school settings without parental consent. And it erred further when it invoked the doctrine of constitutional avoidance rather than addressing the immediate and profound constitutional implications of its decision. It could be argued, speculatively but reasonably, that in adopting its maximal interpretation of PrEP Act immunity, the Superior Court has actually undermined the purposes of the PrEP Act by undermining the entrenched and constitutional rights of Mainers to consent to medical interventions, or to put it another way, their right to reject medical interventions and refuse them, and the rights of Maine's parents to the care, custody, and control of their children. By undermining these rights, ironically, the Superior Court may have stimulated the type of vaccine hesitancy that the PrEP Act seems designed to have addressed. This court is reviewing de novo an interpretation of a statute, and in doing so, it must start with a look at the plain meaning of the statute at its text. 42 U.S.C. Section 247D-6D, which is the PrEP Act, does grant immunity for covered persons that are administering covered countermeasures. And the appellees in this as a basis for their argument that these are administration, that the right to consent is a feature of the administration of an emergency use product. That, however, is not the case. And we know it's not the case because the PrEP Act is hardwired with the emergency use authorization statute. It refers expressly to it. There's connective tissue linking these two statutes. And we see that in the definition of covered countermeasure, which can be found in 42 U.S.C. 247D-6D I1. And this definition refers out to the emergency use authorization statute. That statute states that products that have not been licensed by the Food and Drug Administration may circulate in commerce and be used in the marketplace only if the Secretary of Health and Human...
Counsel, I see that
Yes.
the green light is on. I understand the argument you're making, and I don't suggest we always follow everybody else, but are there any cases supporting the interpretation that you are urging upon us? There seem to be plenty supporting the other side.
Your Honor, one is swimming upstream. That has to be acknowledged. On the other hand, all of the cases cited in the briefing, cited by the Superior Court below, have something in common, and that is that they haven't made the arguments we're making here today. They actually haven't considered the interrelationship between the emergency use authorization statute and the PrEP Act. And that's what I'm inviting the court to do today, and that's the conversation I'd like.
I think in a very purposeful way that the vaccine is not a covered countermeasure for the purposes of the statute here?
Your Honor, I'm arguing that in order to be a covered countermeasure, the Secretary must have taken steps to ensure that those using it were properly informed of their option to accept or refuse administration. That's the language of the statute.
So you're centering that on the Secretary needs to establish some process by which authorization, opt-in, opt-out takes place, and that was missing, and therefore the vaccines are not covered. Missing, and therefore the vaccines are not covered countermeasures? Is that what your argument is?
The argument is slightly different. It's that there is a right to accept or refuse this countermeasure. That right exists. The Superior Court acknowledged it. The appellees have acknowledged it. But the argument they've made is that the right exists, and if you can't bring a lawsuit for civil money damages to enforce the right, that's of no moment, because the right still exists.
The right, let me just back you up. What right still exists? The right to sue for medical
the right to
malpractice?
consent or refuse the product.
So is that suit against the Department of Health and Human Services? I mean, they're the ones that, in your argument, messed up and didn't put in the authorization process. The providers here were not part of that mistake. Wouldn't your claim be better focused upon and brought against the Department of Health and Human Services?
Well, Your Honor, the argument isn't that the process wasn't in place. That it was in place, and in fact, the appellees did, to some extent.
So the Secretary did establish conditions on the authorization?
There were conditions on the authorization,
Okay, all right.
which he established through a number of declarations.
All right.
I mean, the PrEP Act clearly doesn't abolish the right to refuse the treatment.
Not expressly, but it does vitiate the right. It hollows out the right. It's
So
not.
what you're saying is you may still have the right, but there's essentially no realistic way to enforce it.
It's meaningless. It's not worth the paper it's printed on if you can't enforce it in a lawsuit for civil money damages. And there is a constitutionally protected right and interest in ensuring access to the courts. And this
But there are a lot of different immunities scattered throughout the law. The fact that there is an immunity by statute doesn't necessarily mean that the right to access the courts is been vitiated.
No, although the immunity mentioned by the appellees in their briefing was sovereign immunity, and that it's different because the momentum in sovereign immunity is with the state.
There are clearly other immunities.
There are other
besides
immunities.
sovereign immunity.
Yes.
What you're complaining about is that there's a limitation of liability when there hasn't been consent. And haven't we said in at least 2 cases that pursuit of a negligence claim is reviewed under a rational basis analysis because it's not a fundamental right? And if we adhere to that, doesn't this statute meet the rational basis test?
Your Honor, the fundamental right at stake here isn't the pursuit of a negligence claim. It's actually, all these claims are heavily imbued with other constitutional import. So we have a fundamental right to bodily integrity.
No one is saying that you can be vaccinated against invasion of liability.
Well,
and that has been, we've deemed that pursuit of a claim, it's like a cap on damages. And haven't we said in that context, it's not a fundamental right?
Well, there's an entire class of claims that are being extinguished. It's not just a cap on the amount of damages or some other type of modification to the contours of the procedure. Our clients' claims are being extinguished.
But that's what Congress intended to do. Congress enacted this really very affirmative statute with a bullet point list. It's like, wow, okay, well, they've really narrowed it down.
Yes, Your Honor, and this is exactly the point I was attempting to make when I referred to the EUA statute, because that statute says that a covered countermeasure is one to which a person has the right to accept or refuse. And that right is being vitiated with this expansive...
Well, the problem is really that the remedy for violation of the right has been essentially vitiated. It's not really that the right has been.
But then this is...
I understand.
Yes, it's an interesting argument, but without a remedy, what is the right?
Except that the right isn't entirely eliminated because there is a remedy should it be serious bodily injury or death or willful misconduct.
And should it not be one of those, then there is no remedy. My clients have no remedy. They have zero remedy, given the Superior Court's interpretation. And I think that's interesting. And as I said in my opening remarks, is that really what Congress intended when it enacted the PrEP Act, that it would strip a whole class of citizens who did not consent to the administration of these products on behalf of their children of their right to sue?
Just to be clear, are you saying that this is not a covered countermeasure under PrEP? Did I hear you correctly? Are you suggesting this does not fall within the definition of
No.
a covered countermeasure? You're conceding that this is.
I am conceding that it is a covered countermeasure. That's definitely the case. But what I am saying is that the immunity only applies if the right to accept or refuse is honored. And if you look at the scope provision in the PrEP Act, so Congress took the time to delineate the immunity. It actually gave us a list of things that are included within the immunity. And it says that it has to be a claim for loss that has a causal relationship with a series of things. And consent is not included among those things. Even though it's an entrenched constitutional right, it's entrenched in our common law, that one has the right to accept or refuse. This court has found repeatedly that that is an ingrained, inculcated right.
So if you,
fundamental right that you talk about here is the right to bodily integrity, but hasn't our jurisprudence already limited that itself?
I don't know that there is a distinction between children and adults when it comes to the right of bodily integrity, Your Honor. And parents, I think, have standing to assert that right on behalf of their children in the form of giving or refusing consent to medical care. There's a fundamental right that parents have to the care, custody, and control of their children, and exercising that right, they make medical decisions on behalf of their children.
Thank you.
Thank you.
Mr. Mavadonis?
Good morning, Your Honor, members of the court. May it please the court. In this appeal, the appellees asked the court to affirm the trial court's decision on the motion to dismiss the pending notice of claim. In this appeal, the primary issue involves one of statutory interpretation. And we ask the court to interpret and apply the PrEP Act according to its plain meaning and consistent with numerous other jurisdictions, both state and federal, in their interpretation and application of the PrEP Act. And as you know, the PrEP Act provides immunity to certain covered or qualified persons. It makes those persons immune from suit and liability under state and federal law for all claims for loss that are either caused by, relating to, resulting from the administration of a countermeasure. And in this case, we know that there was a declaration issued by the Secretary in March 2020 that each appellee is a covered person under the PrEP Act. And therefore,
The green light is on, so I'd like to explore the issue of the constitutional avoidance issue. If someone is arguing that a statute is unconstitutional, how can we avoid addressing that issue?
right, and I think, Your Honor, under the court's sort of statutory interpretation framework, under the rules of construction, the court will presume that a statute is constitutional, that it was passed by the legislature to be constitutional. And if this court can construe it in a reasonable way, that makes it constitutional.
Well, that is a way of addressing the constitutional issue. In other words, if somebody raises the issue that a statute is unconstitutional, if we construe it in a manner that we say meets the Constitution and renders it constitutional, you are addressing the constitutional issue. You can't not address it.
Well, correct, Your Honor. I think you can look at it and determine if it can be interpreted in a way that passes constitutional
But didn't the
law.
Superior Court below just said, I'm not going to address this, I've interpreted it provides clear immunity? That's
Yes,
what
Your
the
Honor. I
statute
believe that
says.
the trial court interpreted or applied, looked at the notice of claim and said there were no constitutional claims being presented, and therefore did not address the constitutionality issues.
But looking at the big picture here, I think most people would sympathize with the plaintiffs and say, your 5-year-old child had an organic compound injected into his body, which you would not have approved, but it was done anyway, that a wrong was done there. We have the act, the PrEP Act itself, which would seem to immunize everything, but as was just been discussed here, if there is in fact a constitutional right to bodily integrity, how does this statute not fly in the face of that, based upon what happened here with this immunity being applied to the wrongdoer?
Right, Your Honor. So I think the constitutional right at issue would be the liberty interest,
Of the parent?
yes, of the right to make medical decisions about.
Yes, yep, and where does that take us?
Where I think the court would then look to the PrEP Act, see if there were, under the rational basis review, are there state interests that support Congress's intent to enact this statute and provide immunity?
In your position, there is in fact a rational basis, which was the crisis created by the COVID pandemic?
Well, yes, and I think the PrEP Act was actually, I think it was discussed in the appellant's brief, the sort of statutory scheme came about in the early 2000s to apply to any kind of public health emergency that could arise. I think there was a prior case, we cited Parker, that involved, I think it was a smallpox outbreak in New York. But it was the same thing. It was a public health emergency that was declared, and I think it's page 52 of the appendix, or starts on 52, page 850. It's the first declaration issued by the Secretary, which addresses in there, sort of one of the bases for enacting the declaration was that, let me get the exact language.
So you're offering up a rationale for a rational basis?
Exactly, yeah. So the declaration stated that the declaration was issued in order to have a sustained, coordinated, proactive response to the COVID-19 outbreak.
The rational, the rational basis test is a well-known, fairly easily met test. If the constitutional interest here at stake is a parent's liberty interest in making medical decisions on behalf of the child, why isn't that a fundamental interest that deserves a higher level?
I think it could, but I think in this case, the PrEP Act would still pass that because the Act allows the declaration that's issued that triggers immunity to be tailored to specific timeframes, to specific geographical regions. And in this specific case, it was obviously a nationwide enactment under the declaration.
Attorney Jenkins suggested that none of the other cases really address the issue at stake presented here, that is the interplay between the PrEP Act and the EUA. Do you agree with that?
I know there's no cases that I'm aware of that address the specific arguments that relate to the EUA as the appellants have set forth. There was a Kansas trial court. It's the MT case cited in our brief. The trial court in Kansas had briefly addressed some constitutional issues, but the Kansas appellate court then overruled that decision and held that PrEP Act immunity did apply.
Are there any cases specifically addressing the level of scrutiny to be applied on the constitutional challenge to the PrEP Act?
Not that I'm aware of, Your Honor.
Can you comment briefly on the statute that authorizes the emergency use authorization? It does have some squirrely language in there to the effect that it does require the Secretary of Health and Human Services to establish conditions on the authorization to the extent practicable, whatever that means, to ensure that individuals to whom the product is administered have the option to accept or refuse administration. The DHHS folks are supposed to create conditions on an authorization that they'll know that people have been advised of their right to turn this down. So my first question is there something lacking here in the EUA statute or what the Secretary did?
I don't believe there's anything lacking that the Secretary did. I think the section that the appellants have relied on, our position, as I think we had stated in the brief, is that's only an obligation on the Secretary. That does not impose obligations on any of the appellees. In this case, there is attached to the notice of claim at page 33 of the appendix, the consent form that was provided. So I think, excuse me, there's an allegation in the notice of claim clearly that a consent wasn't obtained, but I think to the extent that anything in the EUA statute puts an obligation on any of the appellees.
I mean, the facts that are raised here almost do amount to a willful, I mean, apparently the physician administering the vaccine was this child's actual physician, had, or at least based on the allegations, and they had already had a discussion with the parents about vaccinating. The parents had already refused vaccination and didn't return the consent form here, and despite all of that, they proceeded to immunize his child anyway. It's pretty egregious.
Yeah, Your Honor, and I think looking at the notice of claim, I don't think there is any allegation that this was a willful or malicious act. There's certainly, multiple allegations that go towards, excuse me, the incident in November when this allegedly occurred.
But the PrEP Act just wipes the slate clean, saying even if you did mess up on this, PrEP Act still gives you a get-out-of-jail-free card.
Well, it does to the extent that, there's a declaration that's enacted and that it's not any of the claims that could be sought through the compensation fund or through the federal court action in Washington, D.C.
That circles us back. So Congress did this. Does it fly in the face of the Constitution? And what if we reach the issue of constitutional interpretation, what standard should we use to address that? Is that the configuration of the case we're looking at right now?
I think yes. Well, yeah, I think yes. Does it provide immunity in this circumstance? And if the court addresses the constitutional piece, I'm not sure if I think the question was posed before whether that should be sent back to the trial court for review. But
Did anyone notify the U.S. Attorney General that the issue of the constitutionality of the statute was at play in this case?
not that I'm aware of, Your Honor.
So would that, if we were going to address the constitutionality of this, would it make sense to alert them, to give them the opportunity on remand to present their position on this?
I think that would make sense, Your Honor. I know there's a statute under state law that requires, notification to the Attorney General. I can't say that I know there's a specific federal statute that does the same thing, but I think it would be.
Well, there's a federal statute that says that in federal cases, you have to tell the U.S. Attorney General.
Okay, well, I was just saying I didn't know about the specific statute.
I'm unaware of a statute or a rule that says they have to be notified, the U.S. in a state case. But if we were going to look at this issue, or there was a possibility of finding that it had a constitutional concern and there was a direct attack on it, then would it behoove us to get the U.S. Attorney General notified?
I think it would, Your Honor.
And just to confirm, if we feel that we need to address the constitutional issue, do I understand you say that you should be forward?
Yeah, I don't believe that the Superior Court addressed, had any analysis in its order as to the constitutionality. It sort of, relied on the canon of constitutional avoidance and some other cases that have proceeded in the same fashion.
Well, if it's a rational basis analysis, then we can come up with any reason on our own. And so if we accepted all the allegations as true, there'd be less of a, there wouldn't be a factual dispute at that point to support a remand for the purpose of fact-finding, would there?
No, it would just be purely a legal issue.
And that's the case with respect to a strict scrutiny standard as well.
Right.
At page 23 of the appendix, the notice of claim contains a paragraph indicating that the physician made a phone call to the child's parents later and requested that the child continue with booster shots. Does that call reflect back on the injection and suggest that the administration of the injection without parental consent was willful?
Is this paragraph 26 that you're looking at?
Paragraph
Your Honor?
26, yes.
I don't see it as that, Your Honor, but I think if the court construed that as an allegation as to willfulness, I think the result of that would, I guess backing up to the statute, the PrEP Act has claims that involve willful misconduct.
Well, doesn't it both have to be willful misconduct and it has to be serious physical injury? Don't you have to
get
have
the-
both under the statute to recover?
Under the, to
PrEP.
proceed to the federal court?
Yes.
Yes.
So even if it was willful, then if there's no death or serious physical injury, there still wouldn't, liability, there wouldn't be any liability.
Correct.
There don't appear to be additional questions. Thank you, counsel.
Thank you.
And Attorney Jenkins, I believe you reserve 3 minutes for rebuttal.
Yes, Your Honor, thank you. I'd just like to revisit briefly the conversation we were having about the covered countermeasure and whether that we're saying this is not a covered countermeasure. I think what as a threshold matter, this is a Pfizer COVID-19 vaccine. It's clearly the intention of the Secretary of Department of Health and Human Services that it is a covered countermeasure. It was identified as such, okay? But what we're saying is they're not entitled to immunity if consent is disregarded. That's what we're saying. And we're saying that, and we're getting to that point.
But you agree that the PrEP Act doesn't say that. You're saying that because the EUA, emergency authorization.
Use authorization.
Thank you. Sometimes acronyms mix me up. That is really saying that the right protects the right to refuse any interventions, and as a result of that is why your clients have a claim. But the language of the PrEP Act itself clearly forecloses the claim, don't you think?
I do not.
Okay.
And the reason is that the emergency use authorization statute is acknowledging that there's a right to consent or refuse. It acknowledges that right. And we're told this PrEP Act refers us out to that statute when it comes time to define covered countermeasure and what it means. So it's obviously significant, that requirement of consent. And it's not listed within the scope of the matters that are subject to the immunity. It's not specifically listed. And it's separate from administration.
Consent's not listed, but the language is very broad.
It's broad, but as Justice Scalia and Justice Ginsburg agreed, when they were looking at the ERISA statute, just because there's broad sweeping language in a statute doesn't end the analysis. You have to look at the purpose of Congress, the intent of that statute, and other extrinsic matters. And I think that's appropriate here because on the one hand, the EUA statute's trying to protect consent. On the other hand, this PrEP Act, the way it's being interpreted, is vitiating consent.
So
there's a conflict.
your point is that the EUA gives lip service to the importance of consent. And the Secretary has to come up with an informational situation where they're advised of it. And the fact that the PrEP Act refers back to the EUA, that somehow has, it's a bit nuanced argument, but that sweeps in the element of consent into the PrEP Act.
Exactly. What the appellees have said is that we're within administration. This case is about administration. PrEP Act talks about administration. Consent's a part of administration, but it's not. Look at the EUA language. May I just complete my
Finish
answer,
your
Your Honor?
sentence.
Thank you very much. If you look at the EA language, it says the option to accept or refuse administration of the product. They're two distinct things. And the Secretary in his declarations, one of which is referred to in the briefing of the appellees, never modified the definition of administration or provided one that included consent.
Thank you, counsel.
Thank you, Your Honor.
Thank you, counsel, for the argument today. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. As is also our usual practice, I understand that both of you are in front of this court for the first time, and we would ask that you come back and take the greetings of the court.
All rise.
seated. The matter before the court is Washington County 24227, Charles Keegan versus the estate of Phyllis Bradbury et al., the Holmes. And if I see counselor present, if you would introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellants.
Good morning, Your Honors. Gerald Schofield for the appellant Charles Keegan.
Good morning, Your Honor. Benjamin Campo, counsel for the appellee Craig and Melissa Holmes.
And Barry Mills, and I am the attorney for the estate of Phyllis Bradbury and the two personal representatives, William Bradbury and Barbara Ann Shuffler.
Thank you, counsel. We are being streamed live on the web, both by audio and by video. And Mr. Schofield, if you're ready to proceed, we'd be happy to hear your argument.
Good morning, Your Honors. May it please the court. The appellant entered into a contract with the appellee estate to purchase 7 Lower High Street in Eastport, Maine for a certain sum of money on the other condition that he also receive a right of first refusal on an abutting parcel of land at 1 Lower High Street. The estate accepted that offer by signing the contract, only to later breach that other condition by selling the property to the appellee Holmeses without first offering it to the appellant. We are before you today because a non-lawyer drafted the language from the purchase and sale agreement, language that was drafted unartfully at best. However, the language was meant to be binding additional contractual term and not a wish, and the contract was seen, agreed, accepted, and signed by the parties thereto. The intent of Section 26 of the purchase and sale agreement was abundantly clear and had no other purpose other than to give the appellant what he bargained for, contractual right of first refusal to buy the abutting property. The appellant knew it, the realtor knew it, and the appellees knew it because they acknowledged it in writings that were ignored as evidenced by the court below solely due to a realtor's poor draftsmanship within the contract. A right of first refusal is not a standard term in a purchase and sale agreement. In fact, it has no business within a purchase and sale agreement unless the parties intended it to be there. That is why it was added as an other condition under Section 26. Should this court uphold the orders issued by the Superior Court below, it would, in essence, validate the fact that Section 26 of the purchase and sale agreement might as well have read out the Boston Bruins win the Stanley Cup this year. It is long-standing law that courts are not to render contractual provisions meaningless, but that is exactly what was happened here. The Superior Court looked at the 20 words of Section 26 to determine that the language was precatory, and, as such, ruled solely as a matter of law. It did so without considering any extrinsic evidence, which the court should have done because even the language of 26 itself could have two separate meanings. One, precatory as was ruled, or two, as a legally binding provision under other conditions under the purchase and sale agreement, it having no other purpose for being added there. Under the law, the Superior Court had the authority to look to determine if there was any latent ambiguity, an ambiguity that did not appear on the face of Section 26 or within the contract, but which was certainly clear from the intent of the parties and the consideration of any evidence presented before the court below. I ask this honorable court to do so today. If it does, the court will correctly see that the parties meant to have 26 as a binding other condition of the contract, both offered and accepted by the signatures of the parties on the purchase and sale agreement. Simply stated, this court has the ability to right that wrong and to make it clear that parties cannot eke out of contractual obligations merely because of poor draftsmanship of realtors. This court can overturn the orders issued without consideration of all the facts which were viewed in the light most favorable to the appellant below, and remand this matter back to the Superior Court with a finding that the purchase and sale agreement contained a valid right of first refusal and for fair hearing based upon...
Counsel, I see that the green light is on.
I timed that well, Your Honor.
You did very well. I was taken by your opening line about a non-lawyer drafted this, and that's why it's drafted so poorly. Let me suggest we see plenty of things drafted by lawyers equally poorly, but that's a whole...
I'm sure.
That's a whole nother point. Can we, this right, what you're alleging to be a right of first refusal was contained in a purchase and sale agreement for the abutting piece of property, correct?
Yes, Your Honor.
That sale went through.
The subsequent sale?
The sale of 7 High Street.
Yeah, the sequence was my client, the appellant, purchased 7
Right.
Lower High Street. and
So the
then one
purchase
was-
and sale agreement that contains the alleged right of first refusal was for the purchase of 7 Lower High Street, right?
Yes, Your Honor.
That occurred before the sale to the homes.
Yes, Your Honor.
So I guess I'm struggling. It said condition of sale. It didn't seem like there was anything that the sale of number 7 was conditioned on. I mean, the sale went through.
It would be the appellant's position that him entering into the contract in the first instance was conditioned upon him being able to receive the right of first refusal to also buy the immediately abutting property. And but for the seller's agreement to do that, my client wouldn't have bought 7 at all.
But the sellers didn't have to ever sell the abutting piece of property. So whether or not he was going to buy number 7 couldn't possibly have been conditioned upon obtaining number 1 because they didn't have to sell it.
They didn't have to sell it in that instance, in that moment, but the last will and testament of the decedent under Article 6, which is filed with the Washington County Probate Court, does mandate a sale of the property, in which case it would be our position that the personal representatives in this matter would have had a fiduciary obligation to sell that property in accordance with the terms and conditions of the decedent's will, which is why a right of first refusal was considered for that sale within the contract between these clients.
I think everybody in this courtroom would agree, have a meeting of the minds, that you would like to have this judgment vacated.
Yes, Your Honor.
You see where I'm headed with that? It's precatory language. We all agree there's a meeting of the minds that you would like something to happen. But that is precatory. It's not conditioned on anything. It's just a position that you hold, and we recognize that you will hold it. Isn't that the exact analog of what happened here? That your client would like to have an opportunity to have a first refusal on it if they're going to sell it.
Your Honor, I would respectfully disagree and state that the reason that the Section 26 was added in and its other conditions, it doesn't say other wishes, it's a condition. And a condition is something that must happen. And I will agree with Your Honor that the language, albeit poor, was put there by the realtor.
But isn't that the problem? That condition, as you're alleging it, could not have happened prior to the purchase of number 7.
Well, the condition couldn't have happened prior to my client purchasing and entering into the purchase sale agreement. Can you please rephrase,
Or
Your Honor?
completion of the sale of number 7. In other words, it wasn't a condition of the sale of number 7.
It was a condition of my client entering into the contract to purchase number 7 and part of the basis and benefit of his bargain under the underlying purchase and sale agreement. I will enter into this contract to buy 7 Lower High Street from you on the condition that you also give me a right to buy the abutting property when the estate sells it.
Well, I'd like to explore the language of this, what you are referring to as a right of refusal, is it would like the right of first refusal on the sale of the abutting lot if ever sold. So it goes on for an indeterminate time. It doesn't explain the procedures that you would use. It just says, I'd like it if someday you sell it. And so I'd like your response to a paragraph in the restatement, third of property on servitudes, section 3.4, which says strong justification would be required to conclude that any right of first refusal that imposed vague procedures or long waiting periods was not an unreasonable restraint on alienation. So if we were to try to shoehorn this into an actual condition, wouldn't we have an alienation problem?
I don't believe so, Your Honor, because it would be my position that the right of first refusal is personal to the holder thereof, which is the appellant, Mr. Keegan. Section 26 applies to the buyer. It says the buyer would like the right of first refusal. So he is the person who is the one who's supposed to be given the option to match any offer received by the estate and no other person in our view. And the estate, as I already mentioned, was obligated to sell that property due to a probated will that was on record in the Washington County Probate Court.
So it doesn't say it's personal. It doesn't say how long he's got to contemplate the refusal. It doesn't say anything about the procedures by which the first refusal is exercised. And isn't that what the restatement is talking about as being too vague to enforce?
I certainly can't argue with that there's not more details within the contract. That would be disingenuous. But I will say that there are often rights of first refusal that are not artfully drawn and don't contain all of those things, and they can be upheld. And we would say in this instance, the intent and meaning of Section 26 and why it was there was clear.
Do you have a case, a decision, where they use this, where there's similar language and that was deemed good enough, the would-like conditional tense?
I did not find one exactly similar to this, Your Honor.
There don't appear to be additional questions.
Thank you, Your Honors.
Thank you. And Mr. Campo.
Madam Chief Justice, Associate Justices, may it please the Court. As I previously stated, my name is Ben Campo. I represent the appellees in this matter, the purchasers of the subject real estate, Craig and Melissa Holmes. The Superior Court did not err when it dismissed the appellant's complaint. This Washington Superior Court, County Superior Court, was correct. First, in holding that an interpretation of the contract, an unambiguous contract, is a matter of law. That's long-established precedent by this court, and the Superior Court held to that and proceeded that way. And then the Superior Court looked at the language in the contract that was seeking to be enforced, and finding that it was unambiguous, then correctly concluded that it was not a contract. And specifically, it's paragraph 26, as Attorney Schofield was discussing, and that specifically states, buyer would like the right of first refusal on the sale of a budding lot, if ever sold. That language is completely clear, with meaning that virtually everyone in this courtroom and outside this courtroom can understand. And so in the court's interpretation, the court was correct.
Green light is on. Why is that provision there?
Why is the provision?
Why does it exist?
The other conditions?
No, why does it say he'd like it? What's the point of that
I
provision?
think it speaks for itself, is that he wanted to let the sellers know that that's what he would like in the event that that real estate was ever sold.
Well, he could tell them that. I mean, why was it embedded in the language of the contract itself?
I mean, it says it's a condition of the contract.
It's a condition, but, Your Honor, you were correct when you identified the fact that the sale that was covered in this purchase and sale agreement was consummated, and there was no other paperwork that spoke to the condition concerning the right of first refusal. So, in so much as a condition, it's really an aspiration.
Well, counsel, there could be other conditions inserted that require sort of after-the-fact action.
Absolutely.
You know, the seller will improve the property or remove certain things from the real estate. And those are after the sale is consummated. Those actions are contemplated.
And the difference in that is the language you just used, Your Honor, in describing what the conditions would be. Seller will remove the property. That's clear. That's unambiguous. A court, if a case were brought that the seller failed to remove the property after the sale of the real estate, and the language stated within the purchase and sale, seller will remove the real estate within 45 days after the consummation of sale, and the seller failed to do that, that would be enforceable as a breach of contract because it's a clear breach. It's an unambiguous breach. In this case, we have unambiguous language that doesn't provide any meeting of the minds.
But to Justice Connor's point, why put that in there if it didn't have some significance?
I'm only guessing, really, because I represent for one thing, I don't represent any of the parties to the contract itself. And so I'm representing the third-party purchaser. And I think it was to let the seller know, we know you have other land to sell. We are interested in purchasing that land. In fact, we want to be at the front of that line for that land.
We're
And
here on a dismissal, though. I mean, so to the extent people are coming up with ideas about what it might mean or could mean, isn't that then a fact question so that it can't be determined on dismissal, as opposed to, in other words, that it may ultimately turn out to be only merely precatory without consideration, without any sufficient definition to be enforceable? But given that it was included as a condition of the contract, does that make it a fact question?
No, Your Honor, and the reason why is because of the standard of review for unambiguous language in a contract. The language in the contract's unambiguous, and for the court to find ambiguity in this language sets up a horrific situation where courts are finding ambiguity in virtually every real estate contract.
So your argument is that it stops at plain language. It's not ambiguous. We don't mess with anything outside of the four corners of that sentence.
That's what the law says.
If we did say it is ambiguous, and we turn to extrinsic evidence, you would agree then that dismissal would be improper. I'm looking at the complaint where it says the estate and its personal representatives acknowledge the validity of the existence of the right of first refusal, et cetera, that they actually said out loud in writing and in person your right of first refusal. So 12b-6, looking at taking as true the allegations of the complaint, would require dismissal, would require vacating the dismissal.
Could you, I'm a little confused by the question, Your Honor.
Okay, let's say, I'm not saying we would, but let's say that we found the language to be ambiguous. So then we look at the, if it's a 12b-6 motion, we look at the allegations of the contract,
Yes.
complaint. And the complaint here says that the sellers acknowledged that there was in fact a right of first refusal. So the court couldn't possibly grant the 12b-6 dismissal, taking that as true.
As that's worded, yes, Your Honor.
Okay.
Except I think that we then get to the contract itself. And so whether the sellers acknowledge it or the buyers state it, the contract doesn't say it.
Right,
And so-
that would be a good case, a big factor for the trial, but on the four corners of the complaint, it says that they acknowledge that there was a right of first refusal.
Right, that's an allegation which imputes knowledge of the sellers from the buyer.
Right.
And I think that's a factual allegation that probably, while it's accepted as true, I think seller's acknowledgement is a bit of a reach to accept.
Yeah, I'm
as
not
true.
trying to go to, I'm just trying to say, you're saying it stops the plain language. If it didn't, then we'd have to vacate the dismissal under 12b-6.
You're saying it doesn't matter that the sellers may have acknowledged it if it wasn't a contract term in the first place?
Yes, Your Honor. That is exactly what I'm saying, because if you're not bound by contract and you're acknowledging something, that doesn't mean you're bound by something you're not bound by. And so my point being in that situation.
Well, actually, I think it's more whether it exists, whether the right of refusal, first refusal exists or not. They would say it does, and you'd have to take that as a proven fact for 12b-6 purposes. But if it goes to summary judgment or to a trial, then it would take that further step you're talking about.
Yes, but when the court gets an unambiguous contract and is asked to review that, it's on the court at that point to
Right.
factor out those other issues and get right.
I think we're all saying the same thing in different words.
Okay. Sorry, Your Honor, for repeating that. I think it's also important to note that there were professionals. It was mentioned a real estate agent was there. This was inartfully drafted, and lawyers inartfully draft documents all the time. But there was no other, within the record, there's no other reference to any other document stating that there was a right of first refusal, only the condition in the contract.
Thank you.
And I think that's fatal to the appellant's claim.
Thank you, Mr. Campo.
Morning, Your Honors.
Good morning, Mr. Mills. Can
Hi.
I follow up a little bit on a question that I think Justice Meade was asking, as well as Justice Connors?
We're talking
Even
about
if the language of the term is precatory, when we talk about whether something's ambiguous, don't we start with the language of the specific term, but also look at it in light of the contract as a whole? And so what we've got here is allegations and a contract that indicates that perhaps Your clients acknowledged the right of first refusal. It was stated that it was a condition of the sale of Lot 7. Doesn't that give, and there had to be a purpose for including that, doesn't all of that, at least taken together, at least raise a question as to the ambiguity of the term and whether it ought to be sussed out as a fact question?
If this contract is, ought to be ambiguous, then any contract containing precatory language would also be ambiguous. Buyer hopes to pay the closing, hopes to pay the deposit by December 1. Is that an enforceable contract? Is that enforceable? Is it ambiguous?
Your client, though, took action as if it had meaning. They called Mr. Keegan and informed him and asked him if he wanted to exercise, did they not?
Well, yes, they knew that he was a potential buyer. And I suggest that's probably the purpose of putting it into the contract. Look, I'm a potential buyer here if you want to sell. And if I'm a seller and I know there's a potential buyer, that's going to be my first call. I might avoid a broker's commission.
So you're saying it's no different than me going to my neighbor and saying, if you ever sell, give me a call if you're ever interested in selling. There's nothing really enforceable or contractual about that, but they certainly at least know that I might be interested. And
Certainly, and when you say, when you characterize this as a condition, which was the caption, but what is the condition? I hope to buy the property. I wish to buy the property. Okay, I agree. That is your wish. But I haven't granted it. And we go back to one of the most memorable points of Contract 1, many years ago, in out-of-state law school, was Owen versus Tunson. And that was a case that came out of Bucksport. And I cited that in my brief, in which one said, I'd like to buy your property. And the fellow said, I couldn't sell it for less than $16,000. I said, I agree. There was no contract. And the professor said, beat it into our head. What constitutes an offer for purposes of a contract? And Owen versus Tennyson, he said, is one of the primary cases in the law of contract. And perhaps others here in this room also experienced Owen versus Tennyson in Contracts 1. It is basic to the law of contract that there must be an offer and there must be an acceptance. And here we have neither an offer, we have an expression of a wish. And that's all that we have. And if this is valid, think of what this does to lawyers drawing future contracts. You're going to end up with a mess. I mean, if this will suffice, then think of the awful documents that are going to come in front of you that require interpretation. Is it ambiguous or is it not ambiguous? And there are careers to be made that should not be made on that issue alone. Clean up the law of, at least don't mess up the law of contracts. We have a good working system right now that it works. I was assigned to the rule against perpetuities. And the rule against perpetuities, I'd be happy to argue that. One of the...
Well, I believe his argument is that it's personal to him, so it's limited with a live person. What's your response to that
There was
argument?
nothing in the contract that says it is personal to him. You give me a right of first refusal.
well, it doesn't say that his heirs and assigns are bound, only that he's bound.
Doesn't say either way.
Okay.
Doesn't say either way. We can only
Under the
speculate.
statute, it's either the common law rule against perpetuities, the life and being plus 21 years, or if in fact it would vest or did vest within 90 years. And if this was a right of first refusal that was contractually bound, it's already vested, right? Because
No, it is not vested. And an option is not a vested contract.
It wasn't vested at the time, but isn't it vested now, within 90 years?
No, it never did become vested. It never became more than a contractual right. The first, There was cited in the appellant's reply brief Van Dam versus Speckler. And when I first saw that, I thought, oh gosh, here's a problem. Van Dam versus Speckler said a right of first refusal becomes an enforceable option upon its exercise. But there's nothing in the Van Dam case that says the option is a vested interest. In fact,
But didn't he try to exercise the right of first refusal within 90 years?
right, and he couldn't do it, and he never did. If he had, Black's Dictionary, talking about vested, to confer ownership on a person, to invest a person with full title. You have to have a right, a vested, a final right. An interesting case is Klassen versus City of Newton, a 2015 Kansas case which is admittedly unpublished, but Klassen versus Newton contains a lot of citations to other authority around the country saying that an option is not a vested interest. And when he exercised his right of first refusal, if he ever did, he would have acquired at most, at that point, an option. He would not have a vested right until he acquired ownership. An option is not a vested interest in property, and I found no cases contrary to the Klassen decision. If you have any other questions, I'd be happy to respond to them.
There don't appear to be. Thank you.
Well, thank you very much.
And Attorney Schofield.
Thank you, Your Honors. Thank you, Counsel. The whole premise of why we're here is a 12B6 motion to dismiss. And the court has to find that there is absolutely zero basis upon which the court could grant any relief if every one of the facts under the complaint is taken as true. And I don't think that the court below can do that. There is clear discrepancy in the language of 26 in whether it's a condition meaning a binding condition, or whether it's merely precatory language. That in and of itself would allow the court to explore ambiguity. Either overt ambiguity, or the law also allows the court to look into latent ambiguity, which isn't apparent on its face.
So are you saying any aspirational language in a contract is ipso facto enforceable?
I'm not saying any language. I'm saying the intent of the language in this contract, phrased in this particular
Because
manner
it's
as
under a heading
condition.
that says conditions.
That's correct, Your Honor.
And
So it's
that's what you're basing ambiguity on.
correct, because it can be interpreted in more than one way. And I think that when you look at the other record evidence in the court below, there's a recorded affidavit wherein Mr. Keegan says, I have a right of first refusal.
But just focusing on the plain language of the contract, it's awfully vague. And doesn't that suggest that it was only meant to be aspirational?
I don't believe so, Your Honor, because it would have no purpose or intent of being there if that were to be the case.
So what if it said condition, I would like to have an easement across the seller's property to get down to the ocean. Have they created an easement by simply saying in there, I'd like to have one?
It would depend on the circumstances of how it was added and what it said.
It
But in
says, I would
theory,
like
it's
to have an
possible.
easement.
If you were only going to buy that second abutting property, if you got an easement to be able to get to the property you're purchasing, then sure, I would say that's valid and enforceable. And the law actually says that if a location of an easement is not written into it, then the holder of that easement, right, can situate that easement on the face of the earth. So I would say it is a contractual obligation.
So precatory language under a heading conditional becomes enforceable.
In the circumstances of the purchase and sale agreement of which we are talking about, I would say yes, it does, Your Honor,
Well,
respectfully.
does it make clear that the condition is requiring right first refusal is related to the actual sale of property? Again, the sale was consummated in section 7. The language says conditional,
The language says other...
but not as to the sale.
No, it says a condition of the contract, of the purchase and sale agreement, looking at the entire instrument as a whole, as the court should have done, is that I'm entering into this contract with each one of the 26 to 29 sections, I can't remember exactly how many, Your Honor, need to be given meaning and intent. And if we just scribble out one that says, well, it says would like to, but also references the map and lot number with specificity. I know exactly which property, when I go into the town of Eastport's tax assessor's records, that he contracted to be able to have a right of first refusal over. There's no ambiguity there.
Thank
And
you,
he
counsel.
knew, based upon the estate and the probate records, that that property needed to be sold. And he said, if I'm going to buy this one, I want to secure my right to buy this by the purchase and sale agreement.
Thank you, counsel.
Thank you, Your Honors. I appreciate it very much.
Thank you for the arguments this morning. As is our usual practice, we will be taking the matter under advisement and issuing a written decision in due course. However, as is also our usual practice, I understand, Mr. Schofield, that this is your first argument in front of this court, and we would invite counsel back to take the greetings of the court.
All rise.